down.
Let's go, ma'am. Window down. Off.
There's a permit right there on the
I
dash.
see it. Doesn't matter. Step out of the vehicle.
I'm lawfully parked.
Out now.
I'm getting out. My hands are visible.
Keep them that way.
I'm recording this interaction.
Not anymore, you aren't. Stand right there. Hands where I can see them.
Fine. There's no need for this.
We'll see. Don't move.
The police lights were already flashing before she even turned off the engine. And in that single moment, a simple parking stop became something darker, something heavier, something that would end careers, drain city funds, and expose how quickly authority can turn into humiliation when race enters the picture. Before I continue, where are you watching from right now? Drop your location in the comments. And if you care about real accountability stories like this, please subscribe. It truly helps keep these stories alive. The parking space sat directly in front of the Harold H. Burton Federal Courthouse in downtown Cleveland. The sign was large, clean, and impossible to miss. Authorized judicial parking only. 8 in the morning to 6 in the evening. Towelway zone. It had stood there for years, unchanged, unquestioned, respected. Judges parked there every day. Staff walked past it daily. Nothing about the space was confusing. At exactly 2:27 p.m. on a warm Tuesday afternoon in September 2024, Judge Alana Reeves guided her silver Nissan into that space. She did not rush. She did not sneak. She did not hesitate. She parked the way someone does when they know they belong. On her dashboard sat her federal judiciary permit, flat, centered, and clearly visible through the windshield. Her name was printed on it. Her title was printed on it. The seal of the United States courts sat boldly in the corner. Judge Reeves was 49 years old. She wore a navy suit and low heels. Her briefcase rested on the passenger seat. She had a hearing scheduled for 2:45 p.m., and she was early. That mattered to her. Being prepared mattered. Being on time mattered. Order mattered. She reached for her door handle. The knock came hard. Not a polite tap. Not a warning knock. It was sharp and aggressive, the kind that makes your chest tighten before your brain catches up. She turned and saw a uniformed Cleveland police officer standing inches from her window, pen already scratching against a citation pad. She rolled the window down slowly. The officer did not greet her. He did not ask a question. He gave an order. Window down. Turn the car off. Judge Reeves blinked, confused. She gestured toward the dashboard. The permit was right there. The officer barely looked at it. Step out of the vehicle. She told him she was lawfully parked. She kept her voice steady, calm, professional. She had done this for decades in courtrooms filled with tension. Calm was second nature. The officer repeated the command, louder this time. She opened the door and stepped out, keeping her hands visible, palms open, fingers spread. She announced that she was recording. She announced that she was a federal judge. She announced that she was parked legally. The officer took her phone and placed it on the roof of her car, the camera still running. People were walking past. Court employees, lawyers, visitors. No one stopped. No one intervened. Most did not even slow down. Judge Reeves stood beside her car as the officer ordered her not to move. He questioned the permit. He questioned her right to be there. He questioned her identity. He did not question his own assumptions. She asked why she was being detained. He did not answer. She asked what law she had broken. He said the permit looked fake. That was the moment she understood. This was not about parking. This was about who he thought should be allowed to stand in that space. A black woman in a modest car did not match the picture in his head. He conducted a search. Fast. Rough. Public. His hands checked pockets that held nothing illegal. Nothing threatening. Nothing suspicious. Just keys. Wallet. Phone. When he opened the wallet, everything changed. Inside was her judicial identification card. Official. laminated, sealed. Her photograph stared back at him. Her title was printed clearly beneath her name, United States District Judge. His posture shifted. His shoulders dropped. The confidence drained from his face. He looked again, then again. He finally said it out loud. "You're actually a judge." Judge Reeves did not raise her voice. She did not smile. She did not gloat. She stated facts the same way she did in court. She told him she had said that already. She told him the permit was real. She told him he had no legal basis for the detention, the search, or the seizure of her phone. The phone was still recording. He returned her belongings with shaking hands. He apologized. He called it a misunderstanding. She corrected him, calmly, clearly. There was no misunderstanding. There was an assumption. She checked the time. 4 minutes to her hearing. She asked for his name and badge number. He gave them. Officer Lucas Kane. Badge 5294. Judge Reeves walked into the courthouse with 90 seconds to spare. She took the bench. She ran the hearing. She ruled on motions. No one in that courtroom would have guessed what had just happened outside. But when she returned to her chambers, the calm cracked. She called the chief judge of the district, Judge Harold Wynn. She told him everything. Start to finish. No emotion, just facts. He asked for the video. She sent it. He called her back less than 5 minutes later. His voice was tight, controlled, angry. He told her this should never have happened. He told her this would be addressed. He told her she had every right to pursue legal action. She told him she intended to. 2 weeks later, a lawsuit was filed. The complaint was long, detailed, relentless. It named Officer Kane. It named the city of Cleveland. It listed violations of constitutional rights that Judge Reeves herself had ruled on in other people's cases for years. The video went public. Millions watched a black federal judge be treated like a criminal for parking legally at her own courthouse. And that was only the beginning. The video spread faster than anyone expected. Within hours, it was on local news. By morning, it was national. People watched a calm, well-dressed black woman explain her rights while a uniformed officer ignored them. Viewers saw the permit on the dashboard. They saw the sign behind the car. They saw the search. They saw the moment the officer realized who she was. The comments were not confused. They were furious. Judge Alana Reeves did not speak publicly at first. She went to work. She ruled on cases. She wrote opinions. She let the video speak for itself. But inside the courthouse, the reaction was loud. Clerks whispered. Lawyers stopped mid-sentence when she entered hallways. Marshals checked the front entrance more often. Everyone understood the weight of what had happened. The Cleveland Police Department announced an internal review. The statement was short and careful. It avoided words like racial profiling. It promised transparency. It promised accountability. Judge Reeves had heard promises before. She had ruled on cases built on broken promises. 3 days after the video went public, emails began to arrive. They came from people she had never met. A black surgeon wrote about being stopped outside his hospital while wearing scrubs and an ID badge. A black architect described being questioned while unlocking her own office building. A black business owner said Officer Lucas Kane accused him of loitering outside his shop after hours. The details were different. The pattern was the same. Judge Reeves forwarded every message to her attorney, Nadine Foster. Foster was a civil rights lawyer known for precision and patience. She did not chase headlines. She chased records. She requested stop data, body camera logs, complaint histories. She wanted numbers, not apologies. The numbers were ugly. Over 6 years on the force, Officer Kane had conducted hundreds of stops. More than 80% involved black individuals. His search rate for black citizens was nearly 3 times higher than for white citizens. His arrest rate showed the same imbalance. 14 complaints had been filed against him. None resulted in discipline. Each had been marked unfounded. Each had been closed quietly. The department insisted there was no proof of bias. Foster asked how bias was measured if complaints were never taken seriously. The city had no answer. 2 supervisors were placed on administrative leave. Their job had been to review Officer Kane's conduct. They had approved his reports. They had dismissed concerns. They had failed to act. Meanwhile, Officer Kane was reassigned to desk duty. He did not issue a public statement. His union released one for him, claiming the stop was based on confusion and concern. The video contradicted that claim. The public noticed. Judge Reeves finally spoke at a press conference held on courthouse steps. She did not shout. She did not accuse. She explained. She said she was treated as suspicious before she was treated as human. She said credentials did not protect her. She said silence would protect no one. A reporter asked why she was suing when she already held power. She answered simply, because power should not be required to be treated with dignity. The lawsuit moved quickly. Depositions were scheduled. Records were subpoenaed. Training manuals were reviewed. Officer Kane was questioned under oath. He struggled to explain why he dismissed the permit. He could not name a law that justified the search. He said he felt something was off. That phrase appeared again and again in his testimony. Felt off. During one deposition exchange, he was asked why he believed the permit was fake. He said he had never seen one like it before. He was then shown photos of identical permits used by white judges who parked in the same spaces daily. He had never stopped them. That silence mattered. The city realized the case could not be won. The facts were too clear. The video was too strong. A jury would see what millions already had. Settlement talks began. Judge Reeves had one demand that surprised city officials. She did not want secrecy. She wanted reforms written into the agreement. She wanted training hours, data reviews, automatic audits for racial disparities, independent oversight, real consequences. Negotiations stretched for months. Lawyers argued over language, over money, over control. Judge Reeves refused to bend. She had spent her career enforcing rules. She would not accept soft promises now. Behind closed doors, pressure mounted. Federal officials took notice. Civil rights groups organized. The city faced more than one lawsuit. Officer Kane's pattern was no longer hidden. 3 weeks after the incident, Officer Kane was fired. Not suspended. Fired. His appeal was denied. The video ended his career the same way assumptions had nearly ended Judge Reeves's reputation. The settlement was announced 6 months later. $875,000. The city admitted no wrongdoing in words, but the agreement told a different story. Mandatory bias training. Monthly data analysis. Automatic review of officers with disparities. Independent civilian oversight. Expanded body camera policies. Federal monitoring. Judge Reeves donated every dollar to legal aid groups handling civil rights cases. She said the money was not hers to keep. The message was clear. Accountability had a cost, and Cleveland had paid it. After the announcement, police academy instructors across the state requested permission to use the video for training. They wanted recruits to see how quickly authority could slide into violation. They wanted them to hear calm words ignored. They wanted them to recognize the moment assumptions replaced judgment. Inside the courthouse, Judge Reeves noticed changes. Officers stood farther back. Questions were asked before commands were given. Some behavior shifted out of fear. Some shifted out of learning. Both mattered. She also noticed something else. People stopped her to say thank you. Janitors. Interns. Defendants leaving hearings. They told her they had never seen someone like her treated like that on camera. They told her it made their own experiences feel real. The city council held hearings. Residents spoke. Stories stacked on stories. Patterns became impossible to deny. Data that once lived in spreadsheets now had faces. Judge Reeves attended one session quietly, sitting in the back. She listened as a young black man described being ordered out of his car for no reason. A police captain promised improvements. The words sounded familiar. Later that night, Judge Reeves reviewed cases scheduled for the next day. One involved an unlawful search. Another involved a disputed stop. She applied the law exactly as written. Nothing more. Nothing less. That was her answer. When asked if the ordeal changed her, she said it sharpened her focus. She said the Constitution is only as strong as the people willing to enforce it. She said fairness requires courage when it is uncomfortable. The city tried to move on. Headlines faded, but the reforms stayed. Reports were filed. Numbers were watched. Patterns were flagged. Some officers resisted. Others adjusted. Judge Reeves returned to the same parking space weeks later. Same sign. Same permit. She parked, stepped out, and walked inside. No lights flashed. No knock came. But the lesson remained. What happened there changed policy, careers, and reminded a city who the law serves. Months passed, but the moment outside the courthouse never really faded. It lived on screens, in classrooms, in briefing rooms, and in the quiet calculations people made when they saw a police cruiser slow down near them. The video of Judge Alana Reeves standing still, hands visible, voice calm, became a reference point. Not because she was a judge, but because she was treated like so many others who were not. Inside the Cleveland Police Department, the changes were no longer optional. Every officer was scheduled for mandatory bias training. Not a short seminar. 60 full hours. Attendance was tracked. Participation was required. Some officers complained. Others listened. Supervisors were told that patterns would now be reviewed monthly, not buried annually. Numbers that once sat ignored were now red flags. An independent civilian review board was formed. Its members came from different backgrounds. Retired teachers, former prosecutors, community advocates, data analysts. They had authority. They had access. They were not symbolic. For the first time, officers understood that complaints would not disappear quietly. The federal monitoring began soon after. Reports were submitted. Audits were conducted. Stops were analyzed. Race, location, outcome, justification. Excuses that once passed were now questioned. Some officers adjusted their behavior quickly. Others struggled. A few resigned. Officer Lucas Kane was no longer part of the force. He worked security at a private warehouse outside the city. He gave no interviews. His name still appeared in training sessions, attached to a clip that froze at the moment he looked at the judicial ID and realized what he had done. Instructors paused the video there. They asked recruits what should have happened earlier. Silence often followed. Judge Reeves continued her work. She presided over trials. She reviewed motions. She ruled on police conduct cases with the same standard she always had. Evidence. Law. Facts. Nothing personal. She did not become harsher. She became sharper. One case stood out. A young black man had been stopped for a broken taillight. The stop escalated. A search followed. Evidence was found. The defense argued the search was unlawful. The prosecution insisted it was justified. Judge Reeves watched the body camera footage carefully. She saw hesitation. She saw vague language. She saw no clear legal basis. She suppressed the evidence. In her written opinion, she did not mention her own experience. She cited precedent. She cited the Constitution. She explained that discomfort was not suspicion and assumptions were not probable cause. The ruling was later cited by other courts. Outside the courtroom, people noticed. Civil rights attorneys referenced her case history. Police departments reviewed her opinions. Some praised her clarity. Others criticized her firmness. She did not respond to either. The city of Cleveland released its first annual stop analysis under the new system. The numbers showed improvement. Disparities decreased. Reviews increased. Discipline followed when patterns emerged. It was not perfect, but it was movement. Community meetings were held. Officers attended without uniforms. Residents spoke without fear of interruption. Stories were shared. Tension existed. So did honesty. Progress was uneven, but it was visible. Judge Reeves attended one of those meetings quietly. She sat in the second row. She listened. When someone recognized her, the room shifted. A young woman stood and thanked her. She said the video made her feel less invisible. Others nodded. Judge Reeves spoke briefly. She said the law only works when it applies to everyone. She said dignity should not depend on profession or title. She said reform requires patience and pressure at the same time. The video reached 7 million views. It was shown in law schools, in police academies, in civil rights seminars. Students paused at the moment Officer Kane dismissed the permit. They asked why he did not look closer. The answer was always the same. He thought he already knew. Years later, Judge Reeves was asked if she still parked in front of the courthouse. She said yes. She said she refused to surrender space she had earned. She said fear could not dictate her routine. She said awareness did not mean retreat. She still drove the same car. She still placed the permit on the dashboard. She still walked past the same sign. Sometimes officers nodded. Sometimes they looked away. No one knocked. The settlement money continued to fund legal aid cases. Tenants fighting unlawful evictions. Workers facing discrimination. Families seeking accountability. Judge Reeves received letters from people she had never met, thanking her for choosing reform over silence. When asked if the outcome was worth it, she answered carefully. She said no one should have to endure humiliation to produce change. She said justice should not require video evidence to be believed. She said progress built on pain is still progress, but it should not be the standard. The city tried to move forward. The department adjusted. The public remained watchful. Accountability became a word backed by process, not press releases. Judge Reeves kept the video on her phone. She did not watch it often, but she kept it because it reminded her of two truths. One, that power does not protect against bias. And two, that documentation matters. She continued to rule fairly, to challenge weak arguments, to protect rights, to enforce limits on authority. Her experience did not harden her. It focused her. What happened outside that courthouse changed one city, one department, and countless conversations. It reminded people that injustice does not always shout. Sometimes it knocks quietly on a window and assumes you do not belong. And sometimes accountability answers back.